Welcome to the Wagas Innovation Talks. This podcast offers you an insight into recent innovations in the tech business, driven by research and industry insight. We are talking to researchers and professionals to share their expertise, experience, and projects with us. As a think tank and accelerator, we support tech startups and corporations in growing their business. We believe innovation is key to growth and hope to shine light on academic research and experts with real-life industry experience. To learn more, visit wagas-group.com and find all our podcast episodes plus articles and resources to expand your horizon on tech innovations. My name is Livia van Herde, Marketing and Sales Manager at Wagas, and today we had the honor to welcome Frederic Gaillarde to the podcast. Frederic is a judicial patent expert for France and Europe. He received his degree in business administration from Centre d'études internationales de la Propriété Intellectuelle, CEIPI. He worked at Boisse Colas as French and European patent attorney in Paris for 10 years until he became partner at the law office Germain Maurau and stayed in the position for 11 years. On top of that, he held a dual position as court appoint and patent expert for the Court of Appeals in Paris. Another one of his career successes is his position as member of the board and treasurer at the European Patent Practitioners and as a member of the council at the Institute of Professional Representatives before the European Patent Office. In 2018, he co-founded the cabinet FGPI, an all-encompassing patent litigation firm. His work as French and European patent attorney includes protecting technical innovations by patents, suing infringers, defending clients from accused infringement, legal advice and assessment of patent portfolios in France and abroad. Welcome to the podcast, Frederic.
Hello, good morning.
So let's just jump right into it. Can you explain the historical differences in IP protection between China and the rest of the world?
Yes, actually, there used to be a lot of differences in about 20 years ago because China was not very active in protecting IP rights. But during the past years, there has been a lot of effort towards harmonization between IP in China and the rest of the world. And as you know, China is part of the OMC. And as such, it made a lot of efforts to have IP rights respected in China. So now what we can say is that in China, we have about the same standards of IP rights as in the major industrialized countries.
What do you say are the main evolutions in the past decade that we observed in China regarding IP rights?
Well, as I just said, about 20 years ago, 25 years ago, there was there were not big efforts for protecting IP rights in China,
Yeah.
and there was a lot of there were a lot of cases of infringement, especially concerning goods of Western American and other companies. And little by little, China tried to enforce IP rights, and there has been a lot of efforts put on a judicial system in order to have specialized judges that can now consider the cases for IP and give really very sharp and relevant decisions.
And how can foreign companies effectively protect their IP in China?
Well, you have about the same system for protecting patents, trademarks, and designs in China as in other countries. And you can use the services of private IP firms in order to prosecute and defend your cases in China. And in case you have a litigation, as I said before, you have specialized courts which consider the cases that you submit them, and they give very relevant and quick decisions regarding infringement of IP rights, whatever the nationality of the holder of the rights.
So why is that companies are fearing issues regarding IP rights in China? They think that it's very different to other countries. Why is that?
What you say, is, Livia, is that you believe companies have a different approach in China than in other countries, right?
Yes, yeah.
But precisely because there was this past attitude of China, which was rather passive concerning IP
Yeah.
rights, and this was true for really many years. But now that China has switched to a market economy, they use the same tools as other countries in order to protect the monopolies of companies which are innovative. And what we have to be conscious is that things have changed, and what was true some decades ago is no longer true now, and you can obtain very relevant decisions in China as you can obtain in other countries where you have really strong IP systems.
And what are the latest trends between the Far East and Western countries in regards to IP protection?
Uh, I I would say that the the trend is really a trend of harmonization, and where we had differences before, we now have many similarities, and there are a lot of conferences on IP which take place where the people who decide to work on the laws speak with each other, and they try to find a harmonized system, because if you have the same rules in different parts of the world, that's really from a legal point of view, that's very securing, and that eases the trade between the countries, and this is really helping companies to export and to have their rights enforced anywhere in the world.
Have you seen any other trends as well, or any ideas what could become a trend in the future?
What we can see also is that many countries work on sharing information using the internet, and to try to put for users of IP rights as many info as possible on digital support. And there are lots of programs which are working on this, and it's very helping today to have information regarding IP system anywhere in the world through your through the internet, because that was not working this way some years ago, where you had to
Yeah.
really look for a long time about the information you were seeking for. Now everything is really at the tip of your fingers, and this is a really a good trend, I think.
And what do you personally think? What are the top priorities for global IP protection that needs to be amended?
I think there are two main priorities, which have been asked for by IP users for a long time. The first priority is to try to lower as much as possible the cost of IP, because we still have very heavy taxes in order to maintain alive the IP titles in
Yeah,
all countries.
yeah,
And the second priority is a question of speed, because it takes still too long to have, for instance, a patent granted.
yeah.
The prosecution time is rather long, and it's also very long to obtain, in some countries, to obtain a decision from a court in a case of infringement. It can take typically between 18 and 24 months. And this is because there are many cases which are filed before the courts, and there is really an expectation from IP users
Yeah.
to have strong decisions which are enforced quickly.
Yeah.
And I think that the third priority could be to have centralized courts giving decisions for a group of countries instead of decisions country by country. This would give really much more power to these decisions because it will save time and money for the user, who will no longer have to file cases in each country where they have a case for infringement.
We've reached the end of our podcast episode. Thank you so much for your insight, Frederic. It was a pleasure to have you on.
Thank you, Olivia.
You can read more at wagas-group.com. This has been your Innovation Talks podcast produced by Livia van Herde. Make sure to check back next month for the latest insight in innovation.